find out and get an answer.
Thank you.
To see where the conflict is and
Thank you,
some
Mr.
resolution to it. So thank you. Would you like to continue then?
Yes.
Thank you very much. School
Always
approval.
want to continue. School approvals. BPPE, the board advises all private vocational nursing and psych-tech programs that approval by the Bureau of Private Post-Secondary Education, BPPE, is required in addition to approval by the board. If approved by the board specifies that the program must submit documentation submitting approval by the BPPE prior to commencement of the initial class. The board also directly notifies BPPE of the approval to commence a new VN or PT program or a board revocation of approval of a PT or VN program. The most recent memo of understanding between the board and BPPE was executed in August 2011. The MOU remains in effect until mutually terminated. Revisions may be made at the request of either party but require concurrence prior to execution. The MOU specifies a joint review and approval processes. Proposed programs. In February 2014, the backlog of proposed program applications totaled 145. At that time, the board authorized a moratorium on the analysis of new proposals until February 28, 2015, so that board staff could work on eliminating the backlog. Currently, there are 27 proposals remaining, and the projected completion date is May 31st, 2015. On February 13th, the board extended the moratorium through February 2016 to ensure the staff has time to review the correction of program deficiencies identified by the board. And if this is completed prior to February 2016, board staff will recommend the lifting of the moratorium.
Doesn't the board consider it a priority to approve these schools in light of the workforce shortage that we have? So why didn't the board redirect staff to
Well, the problem
reduce that or eliminate the moratorium so that more approval could come?
Oh, I'm sorry.
No, thank you.
The nursing education consultant staff are the ones who approve the programs. And prior to last year, we only had like 2 of them. One was a supervisor and one was a regular consultant to approve all these programs. And I can't remember how many we had at the time. We had over 200 programs, so that we didn't have enough staff to approve the programs. So they were being backlogged. So that was an issue. And as Mr. Bronstein said, in terms of pay, and you heard Trish Hunter talk about the pay for the nursing education consultant that is not equal to the pay that a nurse just working in a
But now you've
hospital would
extended the
make.
moratorium till next year.
Yes, we extend it to next year. However, if it gets done, we have no problem in opening it up again.
All right, thank you.
I'm just on a question on page 22 of the report.
Oh.
It says, on at least my copy of it, that the board indicated in another section of your own report that the prior MOU had expired, but you are maintaining a dialogue with BPPE staff. So do you have an MOU with BPPE, or is it expired? Are you just having a dialogue?
No, we have. Sure.
We do have. I mean, in what we understand is in your own report that it lists an expired MOU.
No. What you're probably referring to is the draft document that we submitted to the Bureau. What that did, it did not mean that the existing MOU was not in effect. And in fact, the actual document that was signed in 2011 says, the memorandum of understanding shall remain in effect until mutually terminated. Revisions may be made at the request of either party, but require concurrence prior to execution. The document that was submitted in July updated terminology. If you recall, the existing one contained terminology related to accreditation. With the last sunset process, the term accreditation, or the process of accreditation, was changed to approval in terms of the board's authority. And that's exactly what was
So do you have an MOU?
Yes, for the new one.
You have an MOU in force. And then the whole issue of this moratorium, and now a second moratorium. I guess it's curious to me because I guess everyone with a huge backlog could just like say, we're just going to have a moratorium until we have time to catch up. It's just a funny way of doing business. It seems like there should be some sense that you're going to actually catch up without telling everyone else they can't even apply for approval. I mean, this is one of your key functions. So what's the rationale? I mean, you really just can't take a timeout. You've got to kind of get your work done.
Right. And with speaking to the backlog in the moratorium, we've been able to reduce the number of schools that are waiting for approval. But we wanted, as a board, the main focus of the NECs to work with the schools that are already in place.
Right, but you can understand that it's easy to make your number. I mean, how many have been affected by the moratorium? So you're down to 27 left. So how many
How many
are
did we start with?
waiting? No, how many are waiting to put their paperwork in, but they can't because there's a moratorium?
No,
Yes, where are the new applicants and how many are there? Because it's a false number if you're just getting down your number from 100 and something down to 27, but there's like a backlog that they just haven't, it's not reality if they're all waiting. Maybe they aren't, maybe there are no more programs that want approval, but are there 100 waiting? And
Right now
once the
there-
moratorium's lifted, you're going to be right back where you were?
Right now, we have 4 waiting.
Just 4?
Just 4, right. And so until we get done with these other ones, I mean, those that are.
The 27.
Cheryl.
So once the moratorium's lifted, we're not going to see a huge deluge of new applicants?
Based on the information that we have to date, the answer would be yes to that. The moratorium, in addition to reviewing those 25, what it also allows us to do, you see, once we review the proposal, which can be up to 3,000 pages, and it's very detailed, complex work. It's not that we write a curriculum for them. The actual institution must do that. Once we go through it and determine where the proposal is deficient, we do provide that information in writing to the submitting individual. They then have the responsibility to correct those deficiencies and submit it. So that the second year is not only to review the 25, but also to allow us to review the resubmissions that have come in that supposedly correct the identified problems.
How did we get to 145 in a backlog?
As I said, we only had 2 consultants to do this work, plus do the work of the other approved programs, however many, there are 185 programs, so that there was no staff to do the work. Despite our trying to hire people, we have a whole history of that. And at the last sunset review, we did mention that. It was part of the last sunset review in terms of the staffing for the nursing education consultants. And we were hoping at the time that there would be we could do something about increasing the salaries of the nursing education consultant. And then nothing was done, and so then we went to the department, Consumer Affairs, and we worked with the Schwarzenegger administration in trying to get this done, but then we were told after a number of meetings that this was
Well, we're a long way away
bargaining
from the
issue.
Schwarzenegger administration.
That's right, definitely. We've been working on this for a long time.
So is DCA here? Is there some representative from DCA here? Because you're basically kind of laying this at their feet.
Well,
that
no,
they
it's
didn't help you
just-
hire anybody.
Well, we were saying that they told us it was a union issue, a collective bargaining issue. So it wasn't their fault. We were asking them to help us, but we were told it was a collective bargaining issue to increase staff, and that we, the board, had no authority to get salaries increased.
We've heard many different excuses or reasons.
So we don't have anyone from DCA in the audience.
And I guess the other part is you indicated that in the last sunset review, this issue was raised then, and usually what we like to do is if they're raised at one, they're not there on the second one or the next one 4 years later, and that's so that's a troubling part of this. So if you'd like to go on then to enforcement, issue 8.
Okay. Let's see. The board has an enforcement task force, and on November 20th, 2014, they presented many recommendations to the full board intended to aid improving the formal discipline process. The recommendations were adopted by the board, including use of the DCA's Division of Investigation CPEI case referral acceptance matrix in determining cases that should be referred to DFI for investigation, and establishing regular meetings with DFI to monitor case status. But just for your own information, and which we, the task force, we told them that since August of 9009, the then former director Steger presented to us his own, it was CPEI priority case matrix that we had been following since 2009. And it essentially is similar to the one that's proposed by that DFI that we're following now. So in no way did we not want to follow what we were supposed to be following in CPEI. And there's been some miscommunication about that, and I don't know how to address it other than that. So now we are increasing communications with DFI. We're meeting with them, and we're going to meet monthly. We have been. We're increasing communications with the Office of Attorney General, as you heard this morning, and the Office of Administrative Hearings. We are participating in the Attorney General's Fast Track pilot program to increase efforts to seek settlement of disciplinary cases as appropriate in accordance with the board's disciplinary guidelines. We're seeking legislative authority to delegate adoption of default decisions to the executive officer, increase the frequency of mail ballot packages and the number of cases in each package to reduce decision processing time, and examine whether a drug diversion program should be considered as a long-term solution to the growing enforcement caseload to protect public safety and reduce delays. So to date, we have 25 cases that are referred to DFI for fiscal year 2014 and 15, and 6 other cases that are currently pending referral. And of course, staff are monitoring incoming complaints to refer cases to DFI for investigation as appropriate. And then in response to concerns regarding its part in the aging of disciplinary cases, the AG developed a fast-track pilot program, which I've already discussed, and we are participating in it since March 1st of 2015. Hopefully, the goal is to reduce case aging by settling conviction and other paper cases as quickly as possible without going to hearing. For cases that result in a hearing, the AG plans to stack cases, that is up to 4 of them, scheduled for hearing on the same date so that we don't have to schedule them down the line, but they can be heard at the same time. And Office of Administrative Hearing has agreed to participate in this project as well, and will identify dates that are available for these hearings. The program is based in San Diego and will be staffed by a dedicated team of AGs, and if successful, it will be deployed throughout the state. Cases are referred to the AG's office with preliminary settlement terms. Any rehabilitation and/or mitigation information needed to determine the appropriate level of discipline is also identified at the time of referral. Cases will be assigned to the fast track by the team of DAGs. Pleadings will be quickly prepared by the assigned DAG, and the board will file the pleading within 15 days of receipt of the pleading. Then the AG will then initiate negotiations with the respondent in an attempt to settle the case. Again, the goal of this initiative is to provide public protection while also reducing case aging. In addition to the fast track program, staff is also reviewing cases currently pending at the AGs in an effort to identify any case that might be appropriate for settlement.
The question of subpoena authority for employees,
Yes.
Are you giving that authority? That was one of the questions raised in the report. Did you answer that?
Yes, no, I was just going to, but
Okay,
we
thank
are,
you.
well, I know in the interest of time, I'm kind of rattling off here, but
That's all right.
we are, we recognize that this is important. We took training once before, earlier in 2009, and there was a delay, and I'm not laying it at DCA's feet, but there was a delay in getting and are getting authority for that, I mean staff. And so we were told to take another training course, which we did. And so we now are waiting, is it to receive approval for our subpoena authority from legal?
Yes, after we completed the training in October, we submitted our draft subpoena to DCA's legal office for review. That draft subpoena had been previously approved by another staff council, but the authority had not been delegated. So we went to training again, submitted the already approved subpoena for review again. This time it was rejected. We were told that it was not adequate. So we've been working on it, and we're ready to submit it again to our newly assigned staff council for review, with the hopes that we'll have subpoena authority very soon.
Well, we're talking about from 2009 to 2015? We still haven't managed to do this?
Well, in 2009, we learned that the authority could be delegated from the director to
But that
the
was when you
executive.
first took training. I mean, that's like 6 years.
Well, at the time, we did not have field investigative staff. All of our cases were being investigated by D of I.
But you still took the training in 2009.
Yes, we
Yes.
did.
Well, that really is a concern, and I mean, I guess there's a lot of concerns around enforcement that are raised here, and from staffing to, timely referral and allegations that cases may have been shelved instead of receiving timely attention, even criminal cases. Can you explain or elaborate on allegations of that nature?
I do not know of those allegations. Cases are opened when they're received in our office, and they're investigated as quickly as possible.
That's terrible to be shelving cases, and we would not do that. So I don't know where that came from. But we haven't shelved cases, my goodness. That's terrible to do that, and I agree. And so we.
Okay, it's good to hear your response on that.
Madam
That's
Chair,
good.
if I may,
Yes.
there's been some talk about the Enforcement Task Force, and I make up one half of the Enforcement Task Force for the board. The reason the task force was formed was because, and is because, that the enforcement delays, we recognize them as unacceptable. The people of the state of California deserve better, our licensees deserve better, the bodies that govern us deserve better. And we understand that. That's why we formed the task force. We went in, we dug pretty deep, and one of the things we realized was that people need to get on the same page and work smarter rather than necessarily harder. Some of the staff were already overloaded with cases. We made some recommendations, and we're not done yet. We are still digging, and we're still going to make recommendations and follow this path to get us where we need to be, because it is important. And we understand why the body would be concerned about such enforcement delays. It's a serious issue.
Thank you.
Right, I just wanted to do a time check. It's 10 minutes to 4. At 4 p.m., we will recess for the state of the judiciary and then reconvene 15 minutes after the Chief Justice stops speaking. So that's the time scheduled now. So we will continue now with item number 10. And some members will have to go down earlier, I know, to get their positions. Item 10 on management, issue 10.
Oh, management and operations of the board. On December 9th, 2014, DCI Internal Audit Office began an internal operational audit of the board. So we're being audited by DCA, and the purpose of the audit is to determine if the board has established strategic planning process to measure the extent to which organizational goals and objectives are achieved, establish policies and procedures to guide staff in effectively handling operational activities, and complied with applicable laws and regulations. And they're analyzing our strategic planning, our performance goals and measures, our licensing, our complaints and enforcement, our personnel duty statements and overtime, our environmental and occupational hazards, cashiering, and other prior issues identified in other audits, external and internal, and other operational activities as appropriate. And it's needless to say, I mean, the board, we take our responsibilities seriously, and I, as the executive officer, I make no decisions based on my own thoughts and feelings. I recognize that the board is the board members are the final decision and policy makers, and everything that we do at this board, I take it to the board, and the board approves it or disapproves it, or they make suggestions as to how to improve whatever it is we're doing. But in no way do we, do I or the staff make changes without going before the board and asking for the board's approval.